morning, everybody. President Trump's ban was conceived on religious bigotry, utterly indifferent to the facts, and it was executed with with a lack of forethought, skill, or diligence. The record here is clear. The president's own words and those of his top advisors show that this ban was something that the president wanted. It was a religious ban, and he wanted it to just be dressed up to make it look legal. Now, opposing counsel had a tough job today. He was trying to make the order into something that it isn't. We are asking the court here to find what it really is. The court heard the arguments and the facts fairly, and the facts are overwhelming. This ban is unlawful, unconstitutional, and un-American, and should be overturned. With that, I'll be happy to answer a question or two.
General Henry, the judge pressed the government's lawyer a lot about evidence to support this national security interest justified ban. Can you talk about how you do this and kind of expand on your question?
Well, I think what the court was getting at was that we have that the president's authority is not unlimited and is subject to the Constitution. And the administration has offered no evidence to support its assertion that the ban was based on national security. On the other hand, the evidence that we have provided is overwhelming. And I think the word the judge used was not a scintilla of evidence on the administration side that the reason for the ban was national security, compared to overwhelming evidence on the Commonwealth side that reasons other than national security, that an improper motive was the real reason for the ban. And that evidence included a group of bipartisan national security experts who say not only does it not advance national security, it actually undermines national security. And at the same time, we've provided overwhelming evidence that the real motivation was a religious ban, and that's something that the administration hasn't even tried to counter.
Attorney General, the judge seemed to really, we don't know what she believes, but she seemed to really accept the idea that this could undermine national security. What is your view on that?
Well, you know, over the years as a lawyer, I've learned not to read too much into what judges and justices may be thinking based on questions, but I think it's a fair point that when you've got such powerful declarations coming from national security experts that say this ban doesn't advance national security, it actually undermines national security, it endangers Americans and our military overseas. That's something that I think everyone should take seriously. And as the court pointed out here, this court, particularly in Alexandria, is one that has heard national security issues in its courtroom many times before.
Sir, why is it important to move forward with this case when there's already a nationwide ban or injunction in effect?
Well, the Washington case right now has a temporary restraining order. Those are short term, and so this case is actually farther along in the sense that we are now at the preliminary injunction stage. If we are successful in getting the court to enter a preliminary injunction, that would allow for the president's ban to not be in effect all the way up until a trial is heard.
Sir, how does this order affect or harm Virginia?
Well, right now, Virginia and Virginia residents are being harmed by this because we've got students and university employees and professors who are unable to travel abroad because their visas will be canceled if they go to an international conference and present their work, for example. We've got businesses here in Virginia with highly skilled employees that may be visa holders, and likewise, they're unable to visit outside the country. So we've seen where some applicants to colleges and universities are withdrawing their applications. I think one of the declarations we submitted identified Virginia Tech as one of the top 10 universities with students from these 7 countries. So there's a lot at stake, and we'll look forward to a ruling soon.
Mr. Attorney General, do you feel a sense of urgency on the timing of this? If you could just address the timing of it, we're all trying to figure out in the larger picture. Are you disappointed that the judge didn't rule on the injunction from the bench, and do you believe that Virginia's case needs to be in the driver's seat, if you will?
Well, this is a monumental case, and the issues are hugely important for a lot of reasons. First of all, individuals and we as a state, as a Commonwealth, are being harmed by it, but also very important constitutional issues. So it's important that courts consider very carefully the arguments that both sides are making and consider the evidence that's before it. And as I mentioned earlier, the administration has provided no evidence in support of its case, where we've been able to not only have an overwhelming amount of evidence, but the administration hasn't even tried to counter it. In terms of whether, where our case is relative to others, we've got an important case that we're moving forward. There are other cases in other parts of the country, and I think with these important issues, it's going to be helpful to have different courts beginning to analyze the law as it begins to work its way up through the appellate process.
Could you go over the rationale for why it's a Muslim ban?
Well, there's the Washington case that the Ninth Circuit just ruled on yesterday. This case here. I know there's one in New York, one in Massachusetts. There are also other individual cases that I think have been filed as well.
You talked about it right at the start of being a
hypothetical findings of fact. I mean, in fact, Mr. Raphael urged the judge not to rule the bench today and wanted to find that. Tell me why that is, why that's important.
At the preliminary injunction stage, as opposed to the temporary restraining order stage, it's a hearing in which the arguments can be further refined and evidence is considered. And so when there's evidence considered, if the court issues findings of fact, then it's reviewed for an abuse of discretion standard, and it's important to build a record as the case goes forward.
Could you tell us your argument about the Muslim ban? Why is it?
The attorney for the DOJ talked about a hypothetical situation where the president might end up getting deposed in this case. If the judge were to try to review his motives in conducting this executive order, DOJ lawyer also talked about the possibility of, going through like what the discovery process would look like. Is that something you are considering? Would you potentially have to depose President Trump as this progresses?
Well, I think the administration lawyer was trying as hard as possible to deflect from some of the real issues that were in the case, the constitutional issues that were being raised. And these are incredibly compelling arguments, and the facts supporting it, that this is in fact the Muslim ban that the president talked about when he was a candidate, and that Rudy Giuliani said, well, the president called him to find a legal way to do this. In other words, give it some veneer that it could be dressed up to make it look like legal. So, we think that we'll be able to present our case and look forward to having that opportunity.
The 3 students that they referred to are the 3 people who aren't allowed back into the country. Could you elaborate on that?
Well, those are people that the administration knows were sent back. There are hundreds and perhaps thousands in Virginia right now who are negatively impacted by the travel ban, because if they leave, their visas will be revoked, and it is creating real, concrete, tangible harm right now.
Were those people in court today, sir? Were those people in court at all?
I didn't see them.
All right.
Okay.
Thanks, guys.